One finds oneself confronted with a spectacle so grotesque, so perfectly emblematic of our degraded political moment, that even the most practiced cynic might be forgiven a moment of stunned disbelief. The President of the United States, a title that once summoned images of Washington crossing the Delaware or Lincoln preserving the Union, now applies principally to a convicted felon who, in the waning days of his 2016 campaign, arranged for his lawyer to pay hush money to an adult film actress with whom he'd allegedly committed adultery, who then falsified business records during his first term to disguise the reimbursement to his fixer, and who now, from the gilded heights of restored power, seeks to erase this inconvenient judicial footnote from history's ledger. Donald Trump's lawyers have filed their appeal of his Manhattan conviction on 34 felony counts of falsifying business records, and the document reads like a compendium of every bad faith argument and procedural whine that modern American jurisprudence permits. This case should never have seen the inside of a courtroom, they declare with the wounded indignation of men who believe their client entitled to a separate system of justice, or rather, no system at all. The appeal describes this as the most politically charged prosecution in our nation's history, a claim that would be risible were it not so revealing. A man convicted by a jury of his peers, after being presented with overwhelming evidence, somehow emerges as the victim, persecuted by the dark machinations of partisan prosecutors. The facts, those stubborn things that refuse to genuflect before power, remain unchanged. In the waning days of the 2016 campaign, as Trump's political aspirations hung precariously in the balance, his personal attorney Michael Cohen arranged a payment of $130,000 to Stormy Daniels. The money was meant to purchase her silence regarding a sexual encounter that Trump has long denied, though his denial loses a certain credibility when one considers the rather substantial sum he paid for the privilege of her discretion. When Trump reimbursed Cohen, these payments were fraudulently recorded as legal expenses, a bit of creative accounting that allowed him to disguise their true nature. The scheme worked brilliantly until it didn't, which is generally how these things go for men who believe themselves immune to consequence. The trial itself was a masterclass in prosecutorial competence. David Pecker, Trump's longtime friend and erstwhile publisher of the National Enquirer, testified about catch-and-kill deals, a journalistic practice so ethically bankrupt that it makes one nostalgic for the good old days when tabloid editors merely made things up rather than actively suppressing true stories for political gain. The jury heard from Hope Hicks, Trump's aide, whose testimony about the campaign's panic over the potential damage of these revelations proved devastating. They were presented with documentary evidence, witness testimony, and the kind of paper trail that only men who believe themselves untouchable would be foolish enough to leave. After considering all of this, 12 citizens, not partisan operatives, not deep state conspirators, but ordinary New Yorkers called to perform their civic duty, unanimously found Trump guilty on all counts. But here is where our story takes its truly Kafkaesque turn. Trump, having lost his federal cases through the simple expedient of winning the presidency, a gambit that allowed his own Justice Department to drop the charges against him, now finds himself unable to escape this state conviction. So his lawyers have embarked on a multi-pronged offensive that would be impressive in its audacity if it weren't so transparently desperate. They invoked the Supreme Court's recent ruling on presidential immunity, arguing that evidence of Trump's official acts as president, discussions with White House staff, social media posts, tainted the trial. Never mind that the crime itself occurred before he ever held office. Never mind that the Supreme Court's immunity ruling was not intended as a retrospective shield for pre-presidential criminality. The argument is essentially that once a man becomes president, the office radiates backwards through time, sanctifying all prior misdeeds. The appeal also demands that Judge Juan Merchan should have recused himself, and here the legal reasoning descends into genuine farce. Merchan, we are told, made political donations totaling $35, $15 to Biden's campaign, $10 each to 2 Democratic causes, $35. One struggles to imagine the kind of corruption that can be purchased for the price of a decent bottle of wine. By this standard, any judge who has ever expressed a political opinion or contributed to a campaign, which is to say, any judge who participates in American democracy, would be disqualified from hearing politically sensitive cases. It is the logic of a toddler who demands a new referee because the current one insists on enforcing the rules. Trump's lawyers also protest that Merchan's daughter works for a political consulting firm that served Democratic clients, a conflict so attenuated that one would need an electron microscope to detect it. But this is the essence of Trump's legal strategy: throw everything at the wall, no matter how absurd, in hopes that something might stick, or that the sheer volume of complaints might exhaust the patience of the courts. It is lawfare as war of attrition, and it depends on the willingness of the system to treat even the most frivolous arguments as worthy of serious consideration. What makes this spectacle particularly nauseating is the timing. Trump now sits in the Oval Office once again, his political resurrection complete, while simultaneously working to erase the one criminal conviction that actually made it to verdict. His other cases, the classified documents prosecution, the federal election interference charges, evaporated upon his re-election, victims of the Justice Department's policy against prosecuting sitting presidents. Only this state case, beyond the reach of his presidential power, survived, and now he deploys every legal maneuver available to destroy it. He has asked federal courts to take jurisdiction over a state case, arguing that the federal officer removal statute, a law dating to the 19th century and designed to protect federal officials from biased state prosecutions, somehow applies to crimes committed before he held federal office. It is an argument of such breadth that it would, if accepted, grant presidents retroactive immunity for any crime they committed en route to power. The portrait that emerges is of a man who believes, who has always believed, that rules are for other people. That law is simply another obstacle to be overcome through wealth, power, and sheer bloody-minded persistence. He was convicted by a jury. He was sentenced by a judge who bent over backwards to accommodate his return to office, imposing an unconditional discharge that carries no punishment whatsoever. And still, it is not enough. The conviction itself, the historical fact that a jury of citizens found him guilty, must be expunged, erased, memory holed. To be a convicted felon and President of the United States is apparently an indignity he cannot bear, even as he bears so many others with such equanimity. One recalls the old maxim about the fish that rots from the head. Here we have a head of state who is himself the source of the rot, and who now seeks to use the power of his office to declare himself pristinely fresh. The appeal will work its way through the courts, and perhaps the judiciary will find some technicality, some procedural irregularity sufficient to overturn the verdict. If so, it will represent not a vindication of justice, but its defeat, a demonstration that enough power, wielded with sufficient ruthlessness, can indeed place a man above the law. But let us suppose for a moment that the appeal fails, that even Trump's newly friendly Supreme Court cannot stomach the contortions necessary to undo a conviction so thoroughly earned. What then? Will he accept the judgment? Will he, at long last, acknowledge that even presidents must answer for their crimes? Anyone familiar with this man's career knows the answer. He will rage, he will claim persecution, he will describe himself as the greatest victim in American history. He will do anything and everything except accept responsibility for actions he certainly committed and for which he was justly convicted. And his supporters will believe him. That is perhaps the most depressing aspect of this entire sordid affair. The appeal is not really aimed at the judges who will hear it. Trump's lawyers are too sophisticated not to understand how weak their arguments are. No, the real audience is the political base that has elevated this grifter to the highest office in the land, not once, but twice. The appeal serves as fodder for the narrative of persecution, more evidence for the mythology of a man besieged by enemies who will stop at nothing to destroy him. That the enemy in this case was a jury of ordinary citizens performing their sworn duty, and that the evidence was overwhelming, matters not at all. In the post-truth landscape of American politics, the appeal itself is the point, not its legal merits. We are left then with a president who is also a felon appealing his felony conviction, who controls the federal prosecutorial apparatus that might investigate him, who appoints the judges who might rule on his appeals, and who commands the loyalty of millions who will dismiss any negative judgment as proof of conspiracy rather than justice. It is a constitutional crisis in slow motion, a demonstration that our system of government assumed a baseline of shame and integrity that no longer obtains. George Orwell understood that the ultimate ambition of totalitarian power is to control not merely what citizens do, but what they believe, to exercise dominion over reality itself. "The party told you to reject the evidence of your eyes and ears," he wrote in 1984. It was their final, most essential command. Trump's appeal is this Orwellian impulse in miniature, the conviction that with enough legal maneuvering, enough brute application of presidential power, a unanimous jury verdict, the most concrete assertion of legal reality, can be unmade, erased, consigned to the memory hole. If this succeeds, we will have learned that in America, power does not merely corrupt, it rewrites. The judges will deliberate, the appeals will proceed, and Donald Trump will remain what he has always been, a man for whom the law is an inconvenience to be evaded rather than a principle to be respected. That such a man occupies the White House tells us everything we need to know about how far we have fallen and how much further we have yet to go.